There is not a syllable in the Constitution that makes a decision of the judiciary of its own force and without regard to its correctness binding upon anybody, either upon the executive or the people. That was Lysander Spooner reminding us of an essential and long forgotten foundational principle of the Constitution. That is, the Constitution is supreme. Not laws passed by Congress, not a president's views, and not the opinions of the Supreme Court. The framers repeatedly affirmed this. So here's the big question for us today. Who then decides when the Constitution is violated? For the founders, the answer was easy. It's everyone. And that's the key to understanding what we're uncovering in this episode today, what real checks and balances are all about. But first of all, welcome and thank you for joining me here on the Path to Liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Wednesday, February 12th, 2025. Let's kick it off with Thomas Jefferson, a letter to William H. Torrance, who Spooner clearly was reading. He was clearly channeling this exact same message. Jefferson was answering a question, whether the judges are invested with exclusive authority to decide on the constitutionality of a law. His answer sounds pretty familiar. Certainly, there is not a word in the Constitution which has given that power to them more than to the executive or legislative branches. Now, unfortunately for us today, most people think that all constitutional questions in all situations for all time are only decided by the federal courts, eventually the Supreme Court. And what they've turned the Constitution into, the Constitution no longer means what the Constitution says. The Constitution no longer means what the ratifiers told us it means. Instead, that view means that the Constitution means what the judges think it means until the judges change their minds. And that is not anywhere close to the system set up by the founders in the Constitution. In fact, that's much closer to the British system that the old revolutionaries fought a long, bloody war to secede from. Thomas Jefferson called it an oligarchy. Here he is to William Charles Jarvis. You seem to consider the judges as the ultimate arbiters of all constitutional questions. A very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. To understand this further, we first have to start with the supremacy clause. That's Article 6, Clause 2 of the Constitution, and let's read the text. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. Michael Stokes Paulson and Luke Paulson, in their book, The Constitution in Introduction, really hammer on this essential foundational part of the Constitution. It's constitutional supremacy. They write, all branches of government are equally bound by the Constitution. No branch of the federal government, not the Congress, not the president, not even the Supreme Court, can legitimately act in ways contrary to the words of the Constitution. That should be very straightforward for us. But they take it further. Indeed, Article 6 requires that all government officials, legislative, executive, and judicial, state and federal, shall be bound by oath or affirmation to support this Constitution. So we start with the Supremacy Clause, and then we get to the oath of office. You have to, that's your job, is to follow the Constitution. And they say, thus, the idea of a written Constitution is closely tied to the idea of constitutional supremacy. Now, if you think about it, the old revolutionaries, again, they fought a long, bloody war to secede from the arbitrary power. Arbitrary power was one of those grievances, the injuries and usurpations, abuses in the Declaration of Independence of the British system of the unwritten British Constitution. That was a system where, well, government could basically make the rules up as it went and change it around, and it never was wrong, ever. But in America, this is back to the Paulsons, in America, no branch of government is supreme. The government as a whole is not supreme. The Constitution is supreme. It is the written Constitution that prevails over every other source of authority in the United States. And we put it like this in a recent post over on X. A lot of people seem to think a president takes an oath to preserve, protect, and defend the opinions of the judicial branch regarding the Constitution of the United States. That is not the oath of office. If that's what the framers wanted, they would have put that in the Constitution, but they did not. Instead, we have, again, Article 2, Section 1, Clause 8 of the Constitution, where the executive is required to take an oath to preserve, protect, and defend the Constitution of the United States. That's the president who takes that particular oath. Now, back to the Supremacy Clause. Here's how Alexander Hamilton put it in Federalist number 33. He said, the clause which declares the supremacy of the laws of the Union only declares a truth. It expressly confines the supremacy to laws made pursuant to the Constitution. And if we're talking about supremacy of the Constitution and following the oath of office, we have to understand, well, human nature. People with power tend to try to expand their power, and government always tends to kind of grow. The founding generation certainly understood this. They also understood the corrupting nature of power, and that people who have it will probably try to cross the line of what they're authorized to do from time to time or all the time. And so they recognize that the judiciary, just like the other branches, it's not like they're infallible just because they're judges. They could also be corrupt and violate the Constitution. And that's why they did not want any one branch having power over the others. Here's how Jefferson put it again in that letter to William Charles Jarvis. Our judges are as honest as other men, and not more so. They have with others the same passions for party, for power, and the privileges of their corps. Now, he uses a Latin phrase here that I cannot read. I am terrible at pronouncing Latin. But their maxim is, it is the role of a good judge to enlarge his jurisdiction. That was the maxim, as Jefferson described it, of judges at the time. And their power, the more dangerous, as they are in office for life and not responsible as the other functionaries are to elective control. And that's why, if you think about it, they wouldn't want to put this kind of unlimited final authority in the hands of these unelected, in essence, unaccountable, politically connected lawyers to have say over what the Constitution means, because the people of the several states are the fountain of all power. This is all the founders agree, Federalist and anti-Federalist alike. And government is only supposed to serve as their agent. They couldn't put one part of that team above all the others and the people as well. And Jefferson put it like this: the Constitution has erected no such single tribunal, knowing that to whatever hands confided with the corruptions of time and party, its members would become despots. And James Madison also discussed he wrote about the potential for abuse by the judiciary in his report of 1800. Talking about the Virginia resolutions of 1798, he said the resolution supposes that dangerous powers not delegated may not only be usurped and executed by the other departments, but that the judicial department also may exercise or sanction dangerous powers beyond the grant of the Constitution. And that brings me back to Lysander Spooner. Again, just reiterating and reaffirming these long lost and forgotten foundational principles from the founding generation. This should just be obvious. He said, if a judicial decision be according to law, it is binding. If not, not. An unconstitutional judicial decision, wrote Spooner, is no more binding than an unconstitutional legislative enactment. And get this, he has always got to add a little bit more here. He said, and a man has the same right to resist by force one as the other, and to be tried for such resistance by a jury who judge of the law for themselves. So for Spooner, you always got to throw in a little bit of jury nullification as a protection of our liberty and an enforcement mechanism for the Constitution. But here's Spooner again, channeling Jefferson, who was referring to judicial supremacy. A lot of people think that judicial review and judicial supremacy is the same thing. They are absolutely not. They think that the notion that when a case comes before a judge in the line of their duty, judicial review is when they say, oh, well, this is our opinion on whether this is constitutional or not. When you convert that to judicial supremacy is when you say that the opinion of the judges are binding over everyone, whether or not it's within the bounds of the Constitution or not, that they are the oligarchic, basically deciders of what the Constitution means. But here's Spooner. He said, if a judicial decision is contrary to the Constitution were binding simply because it were a judicial decision, the judiciary could constitutionally make themselves absolute sovereigns at once. That's so similar to what Jefferson was saying some decades earlier when he said, look, if you think that they are the ultimate and final arbiter of everything, you're actually calling for the despotism of an oligarchy. Not much different than what Spooner said some decades later. He said a judicial decision as such has therefore no intrinsic authority at all. Its constitutional authority rests wholly upon its being in accordance with the Constitution. And Spooner continued, if we take the decision as authority for the meaning of the Constitution, all decisions will of necessity be constitutional. And the judges are, of course, constitutionally speaking, absolute despots. And because the founding generation, they tried very hard to create a system that wouldn't create a consolidated power in the hands of very few people that would lead to a total despotism, they, instead of having judicial or legislative or executive supremacy over the other branches, they created a system of co-equal branches. Jefferson described it like this: the Constitution has more wisely made all the departments co-equal and co-sovereign within themselves. The Constitution, he wrote, in keeping the three departments distinct and independent, restrains the authority of the judges to judiciary organs, as it does the executive and legislative to executive and legislative organs. And the equality, the co-equality, and the independence of these three federal branches means that no branch is the boss. No branch is in charge of the others. None has the power to tell the other branches what they can or cannot do. They can issue opinions and say, I think this is the right way to do it, but they can't force it. Here's how James Madison put it, the father of the Constitution, in Federalist number 49. The several departments, being perfectly coordinate by the terms of their common commission, none of them, it is evident, can pretend to an exclusive or superior right of settling the boundaries between their respective powers. Now, here from a law review paper, The President and the Myth of Judicial Supremacy. Again, that's that phrase that a lot of people think, this is how most people treat the judiciary, as if it's supreme over everybody, not just the other branches, but the states and the people themselves. This is how Paulson was describing Madison's take in Federalist number 49. He said, that is as categorical a rejection of one branch interpretive supremacy and as unequivocal an embrace of interpretive coordinacy as it is possible to imagine. It entails a rejection of judicial supremacy every bit as much as a rejection of congressional supremacy or executive supremacy in constitutional interpretation. Now, I'm already citing a bunch of stuff, articles, a book, some source documents, and the like. All that stuff will be included in the show notes for this episode, like we include for every single episode. We do a blog post over at 10thamendmentcenter.com/path to liberty. My buddy Alan Mosley does an awesome job, very consistent, great work getting that organized for every single episode. And in that, you're going to find a show links section where it's generally put in the order of how I'm going through it in the episode. That way you can read and learn more in context on your own time. Again, Alan Mosley will get that organized, and I will get that published over at 10thamendmentcenter.com/path to liberty. It's all spelled out, 10thamendmentcenter.com/path to liberty. And with that, let's get back to it. I want to discuss some views from Alexander Hamilton. First of all, the important point that judges issue opinions. They don't make laws, and they don't have an enforcement arm. Hamilton discussed this, first of all, in Federalist number 78. He said, the judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or of the wealth of the society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the efficacy of its judgments. He was making the case that really, when you get down to it, the judiciary is kind of the weakest of the three branches, if they're going to be one. So maybe Hamilton wasn't as hardcore on the co-equal part, but this is the argument that he's making on this setup, because the judiciary can issue their opinion, but what can they do to put it in effect? It relies on the enforcement arm, the enforcement branch, that's the executive, in order to give it any efficacy. He revisited this in Federalist 81. He said this may be inferred with certainty from the general nature of the judicial power, from the objects to which it relates, from the manner in which it is exercised, from its comparative weakness, and from its total incapacity to support its usurpations by force. So if the judicial branch usurps power, it can do nothing unless at least one of the other branches agrees. It really, really relies heavily on the executive branch. Here from Carson Holloway in his article Against Judicial Supremacy, he said, Hamilton's assurance here depends on the assumption that the executive might legitimately decide not to lend its force to support a judicial decision that could be considered an encroachment or a usurpation. This in turn supposes that the executive may make its own determination on such questions. So even during the ratification debates, you have people like Alexander Hamilton telling us, well, if the executive branch decides not to put into effect a judicial opinion, well, then it means nothing. They have no force. They have no will. They can only issue judgments. Their opinions, that is. Here's how John Jay put it, along with, I believe, Justice Cushing. John Jay was the first Chief Justice. And this is an opinion with Justice Cushing and Judge Duane of New York in 1792. The court were thereupon unanimously of opinion that by the Constitution of the United States, the government thereof is divided into three distinct and independent branches. And this is the money shot, and that it is the duty of each to abstain from and to oppose encroachments on either. Again, if we're talking about your oath of office, your oath to the Constitution, if any one of the branches is going beyond their limits, it's not just a good idea to just say no. It's a duty to abstain from giving them effect in any way possible under your purview, and to oppose. It's a duty to oppose encroachments of either branch. And that's how they put it unanimously in 1792. Thomas Jefferson reiterated how he put this kind of principle into practice in a number of letters. Here he is to Spencer Roane. He said, each department is truly independent of the others and has an equal right to decide for itself what is the meaning of the Constitution in the cases submitted to its action. And Jefferson certainly did that in response to the Sedition Act, where he dropped prosecutions and he just ended enforcement of the Sedition Act because he saw it as a nullity, which is how he put it over and over throughout his career. And it was no law at all, so it was his duty to refuse to implement it. He went further here in this letter to Roane. He said each of the three departments has equally the right to decide for itself what is its duty under the Constitution. And this is the important part, without any regard to what the others may have decided for themselves under a similar question. And he also had a very similar take in his letter, September. He wrote to Abigail Adams many times. This is September 11th, 1804. He said, "You seem to think it devolved on the judges to decide the validity of the sedition law, but nothing in the Constitution has given them a right to decide for the executive more than to the executive to decide for them." That's what it means to be co-equal and independent branches. They're independent, they act in their own sphere. And he explains how this plays out in practice. Both magistracies are equally independent in the sphere of action assigned to them. The judges, believing the law constitutional, had a right to pass a sentence of fine and imprisonment because that power was placed in their hands by the Constitution. So Jefferson explains how the checks and balances, when you're following your oath of office, when everyone is following their oath of office to the best of their abilities, and you have co-equal branches, this is how it plays out. Well, the judges might hold that something is constitutional. But he said the executive, believing the law to be unconstitutional, was bound to remit the execution of it, because that power has been confided to him by the Constitution. That instrument meant that its coordinate branches should be checks on each other. So over and over, Jefferson made clear, and he acted like this in office, that the judges may have their view, but if you want it to go into effect, I need to agree with you. And on the sedition law, I absolutely do not. And so therefore, I will remit the execution of it. I'm not going to continue with prosecutions. And like he later wrote to William Charles Jarvis, the idea that the judges have the exclusive and final say over what the Constitution means sets us up for a despotism. Here's how he put it to Abigail Adams: "The opinion which gives to the judges the right to decide what laws are constitutional and what not only for themselves and their own sphere of action, but for the legislature and executive also in their spheres, would make the judiciary a despotic branch." But going even further, James Madison, in his report of 1800, put it like this. He explained that the real final authority, the final arbiters of what is constitutional or not, is not even in the federal government at all. He said the states, then, being the parties to the constitutional compact, and in their sovereign capacity, it follows of necessity that there can be no tribunal above their authority to decide in the last resort whether the compact made by them be violated. So this gets back to the notion, to the view of all the founders, that the people of the several states were the top of the food chain. They were the fountain of all power. They were the source of all power. Government is just their agent. And so therefore, the agent doesn't get to determine if the agent followed the rules or not that were given to the agent by the people themselves. The final authority on the Constitution is the people of the several states. That's how he describes states in that context, the people of the several states in their highest sovereign capacity. And Madison took it further. He said, the ultimate right of the parties to the Constitution to judge whether the compact has been dangerously violated must extend to violations by one delegated authority as well as by another, by the judiciary, as well as by the executive or the legislature. So the final authority is definitely not the Supreme Court. It's definitely not the executive. It's not Congress. It's the people of the several states themselves, because they're the ones that created rules for the government through the Constitution. Thomas Jefferson described it like this in his Kentucky Resolutions of 1798, the same position. The government created by this compact was not made the exclusive or final judge of the extent of the powers delegated to itself, since that would have made its discretion and not the Constitution the measure of its power. So again, The Constitution is supreme, not the discretion or the views of people in government. And he said, but that, as in all other cases of compact among parties having no common judge, each party has an equal right to judge for itself, as well of infractions as of the mode and measure of redress. Now, listening to just a little bit of this, without even reading through all the links, the reference links in the show notes, so you can learn more in context on your own time, it should be totally obvious why the government-run schools never, ever, ever teach us any of this. I never learned any of it. And so that's why we work so hard every single day to reach and teach more and more people about these essential, foundational, constitutional principles, about the Constitution, about checks and balances, the supremacy clause, the oath of office, and so much more. Nothing helps us more than the financial faith and support of our members. If you support the work that we do, you want to help us continue trucking along, punching way above our weight class, you can join us for as little as $2 a month over at 10thamendmentcenter.com/members. Again, it's all spelled out, 10thamendmentcenter.com/members. $2 a month. If you got a couple of bucks of that dirty government fiat, please consider throwing that our way. We also have annual, 5-year, and lifetime options. And if you prefer to make a one-time gift without joining as a member, or if you already are a member and want to pitch in a little bit more, no pressure. 10thamendmentcenter.com/donate is where you go for that. I won't belabor the point, but I would be extremely grateful for any consideration you can give to joining us or supporting us financially in any way today. Thank you so much. There's also a number of free and easy peasy things that you can do to help us spread the word, but primarily by triggering the algorithms of the mainstream platforms. A long watch time. The more watch time percentage of the video that you have on YouTube and other mainstream video platforms, the more likely the algorithm will show us to more people. Reviews on Apple Podcasts, any other podcast platform, hitting the like button, comments in the archive, subscribing, getting notifications, all that stuff. Thank you so much. Thank you so much for watching or listening to the show. I really appreciate you being here. I hope you learned something that's more important than anything. And I look forward to seeing you next time here on the path to liberty.